I'm Joe Maskovyak. I'm the, as you can see, Affordable and Fair Housing Coordinator at Ohio. So a little bit about me. That's, like I said, my title. More importantly, from your point of view, I'm a lawyer. And for many years, many years, I was a legal aid lawyer. What does that mean? That means, and I did landlord tenant law, housing law. That means I bring a tenant perspective to all of this because I represented tenants. That was my job. All right. And before I forget, if you have questions, as John said, put them in the chat. I'm more than happy to address questions during the broadcast. In fact, I'd prefer that to whatever extent we can manage. I would prefer a conversation than simply me talking to you, lecturing you. All right. This is a little bit about Ohio, who we are, what we do. We have varied functions. I don't do anything that really has anything to do with homelessness. I do with housing. And among those mission things there, I am very involved with training, like here, the hotline advice. We have a phone, a dedicated line where people can leave messages, and I return calls trying to give them advice. I do plenty of public education like this or upon request. So, and you guys can feel free to contact me with questions, after this is all said and done, and there'll be contact information there. All right, a little roadmap here. So we're going to talk about landlord tenant law and how it works for you. All right, that's all in one chapter of the Ohio Revised Code. That's what ORC stands for. That's chapter 5321. And then we're going to talk about eviction law. That's also all in one chapter, 1923. All right, a little more detail. So we're going to spend a fair amount of time talking about the general applicability of 5321 to recovery housing. And then we're going to do some basics. It's important to know the definitions and what is required of landlords and tenants under Ohio law, in my opinion. And then we'll spend a little time talking about rooming houses. And again, this is an additional piece, special for you guys, because I used to get a lot of questions from folks. Well, we think of ourselves as a rooming house. What about rooming houses? And so you'll get a little bit of information about that. All right, part two, we're going to do a little deeper dive. Hopefully we'll have a chance to get to that stuff about these issues. Many of these issues really come from the housing information line or hotline that I run. These are the kinds of questions that I take and I answer over and over and over again, because people either don't know anything about the law here or they get it wrong, or both. So, part one. So, number one, it's a business relationship. We'll talk more about this later, but why do I say that? Because I know that agreements are made with friends and family. When we talk about rental agreements, I'll talk more about this. But even if it's people that you know or get referred to that are friends, you need to keep it a business relationship. Handshake deals are a bad idea, in my opinion. And as I said, I'll explain more about that later. So, what is a tenant? A tenant is the person entitled under agreement, right, to use, occupy to the exclusion of all others, as you see me bolded there, all right, including landlords. That means including you. So, guests and visitors. Messy stuff. It might not be a bad idea to define a guest versus a visitor, and when a guest may be transformed into a visitor, perhaps by the number of days. Rental agreements, as much as possible, need to be made in unambiguous language. They need to be clear. All right. This lack of clarity creates problems for both sides. They're not sure what is going on. So you'll see that capitalized, bolded. Ambiguity is construed against the drafter. What does that mean? That is a maxim of contract law on how you construe or interpret contracts. Basically, it's saying if you are the drafter and there is ambiguity, you are at fault for creating the ambiguity. So if there's a toss-up on how a provision should be interpreted, it should be interpreted in favor of the tenant, because the tenant almost never has any say in drafting the contract. So it's not their fault that it's unclear. It is the landlord's fault that it's unclear because they drafted the agreement. I say all of that as a cautionary tale for all of you. Take a look at your contracts and try to make them as clear as possible. I think that's a word to the wise. And big bolded, it's a binding legal contract. So it is, you are locked in. You don't get to change the terms in the middle of the agreement. Both sides are bound. I've had more and more of these questions lately since COVID. I just had a question on the hotline yesterday saying, my landlord keeps raising my rent and adding fees. First question I had is, are you in a lease? The answer was yes. Are you in a lease for a specific number of months? The answer was yes. When does your lease end? It ends in about 5 months. Your landlord can't change the terms. They can't say, okay, your rent is now X number of dollars instead of, it's now $500 instead of $400. And we're changing the late fee. It's now going to be $50 instead of $25. And it's late on the 3rd instead of the 5th, regardless of what the lease says. No, landlords don't get to do that. Just like tenants don't get to say, you're charging me too much for rent. I'm only paying you $400 a month now instead of $500 a month because I've decided that the rent is too high. As I tell tenants, you would get laughed out of the office by a landlord, rightfully so. It works both ways. What is good for the goose is good for the gander, as the old saying goes. All right. The purpose of this slide is to let you know that landlords are not just owners, but managers, agents of the landlord. I don't know how many times people tell me, my landlord, oh, I guess they're not my landlord. They don't own the place, they just manage it. And I interrupt them pretty routinely and tell them, under Ohio law, they are a landlord. That is probably with whom you signed a lease, if you signed a lease. That is classically a landlord under Ohio law. One does not need to be an owner. In fact, it is quite likely that the owner is not a landlord if they have hired an agent to manage and sign contracts, and only if they fire the agent and take back control to manage would they then become the landlord, because they have no what is called privity of contract. They have no contractual, they, the owner, have no contractual relationship with the tenant because they didn't sign anything. They've had no dealings with them. So it is the managing agent that is the person who would be the landlord and responsible for everything at that point in time. So we're going to spend a fair amount of time on this. Residential premises. The actual definition, in my opinion, which you see there, is pretty useless. It's where somebody comes in and occupies a place. Well, that's not helpful, my opinion. So this is some of the things that it does not include. However, you should know that in 5321.01C, there is a laundry list of 10 subsections, all of which go on to define those things that are not residential premises and therefore not governed by landlord tenant law and chapter 5321. As I said, many other 10 different provisions, which include many pieces within the 10 provisions. You should know that none of the provisions specifically exempt recovery housing. The importance of that, I will tell you when we get to the end of this piece. So what we're going to do next is talk about a couple of the exclusions, which I have learned to concentrate on because I've gotten a lot of questions and pushback from recovery housing providers saying, well, they shouldn't be landlords because they're really this other thing that is not a landlord and tenant. So they're a facility, but if you're not licensed as a 501c3, you don't qualify. Most I know are not 501c3s. Or you're in this group. You're running something where the period of occupancy is less than 60 days. And when I say that, I don't mean the person sort of ends up being there less than 60 days. I mean, it is mandated that they are only allowed to stay 60 days, less than 60 days. So from my experience and my discussions with recovery housing providers, that really doesn't work because pretty sure people don't get recovered in 59 days. The other single room occupancy is where you do one of the following. As you see bolded, services, licensed, certified, registered, yada, yada, yada. I will not read slides to you because I hate it when people read slides to me. I believe you're perfectly capable of reading and you don't need me to do that for you. And shelter for juvenile runaways, DV victims, that's not you. So we'll concentrate on the first one on the next slide. So what does that mean? So OMAS, the Ohio Department of Mental Health and Addiction Services, which is where you are, they're the ones who would be the state agency licensed, certified, or registered. They certify and license. Now you should know that residential treatment facilities are not part of landlord tenant law, but you have to be a facility and you have to have services that are consistent with what I say there, and you are then regulated by a part of the Ohio Administrative Code, OAC 5160. So they also talk about accreditation and accept accreditation from these types of organizations. Ohio Recovery Housing, which is our host today, also certifies, and they use the national standards. You should know that both OMAS and Ohio Recovery Housing, ORH, both agree that recovery housing providers must follow landlord tenant law. So from what I know, you will not get certification or accreditation if you tell them, I'm not going to follow landlord tenant law. We don't believe landlord tenant law applies to us. You will not then fit into this exemption. The other exception that I've heard recovery housing providers say is, well, really, we're more like a shelter. Shelters are defined under Ohio law. They are defined like you see here. You will notice that the persons that are included are not victims of substance abuse. There are 3 categories. All right. Those categories do not include victims of substance abuse. So back to the beginning of when I started this, where I said there was no exemption, all right, for recovery housing providers. What does that mean? Well, as a part of statutory construction rules, what it means is if there is a list of exemptions and you are not on the list of exemptions, then you are not exempted, and you are included in landlord tenant law. So, John, I often pause here because typically there are questions, and if there are questions, it would be better to address them now rather than later.
Thank you. A couple of questions. So if they were homeless prior to entry in the recovery home, would we be exempt?
No, you have to
Okay.
have it specifically only for homeless people.
And what is ASAM level 3?
I am not familiar. That's a question for OMAS. That is the kind of thing that has to do with residential facilities where you're providing more than housing, but a level of services that is required in order to qualify. It takes you out of landlord tenant law, but you have to be a facility and deemed so by the state of Ohio under the administrative code sections. I don't
And
get calls about that. I don't deal with that. Again, it's a lot more than just providing housing.
right, and I thank you. I replied with a link to that to Gilbert to um, so he could go on and see that it's a more treatment kind of a thing, and
Yes,
it's really in Omos's area. And
absolutely.
just to reconfirm that the rental agreement has to be clear on both sides, but it is the author of the rental agreement that when there is a dispute, the author of the rental agreement uh, uh, I don't know, loses or is held more responsible than the non-author.
That is correct. And that's because, again, this is simple logic and common sense. So if the tenant says, well, that should mean I should get to do this, and the landlord says, no, that's not what it means something else, and it ends up in court, the court is saying, look, which of you is responsible for creating this language that we're here fighting about? It's the landlord. I'm not sure how this should go. All right. I can see a reasonable interpretation on both sides. Because of that, I am going to construe the provision in favor of the tenant since they had no say in creating the language. The landlord did, and we wouldn't be here if the landlord had drafted better.
The author of that question says, thank you. That makes sense.
Good.
And that's it for questions for now.
Okay. Good questions. All right. Rental agreements. So it's any agreement, written or oral. You will see that bolded. Why do I bold that? Because people say, well, I don't really have a lease. It's just an oral agreement. Oral agreements are valid in Ohio. That is a lease. It's not a good idea. All right. It's not the best idea. It's not what I would recommend, as you'll see. All right. It's just people. All right. This is what I tell tenants when they call. I tell them, if you get done and it's a handshake deal, send an email, send a text saying, this is what I understand our agreement to be. If we were in person right now, I would be looking out at you and saying, so I defended a lot of evictions for tenants who had oral agreements. Guess how many times the landlord and tenant agreed on what the oral agreement was? That's right. The answer is zero, nada, never. Now, could it be that people are lying? Sure, but it doesn't have to be. People just remember things differently. That's why it's important to put it in writing. Think about it this way. If you've ever been in an office where there was a meeting, you missed the meeting. So you asked 3 people, what happened at the meeting? What was important? How many answers do you get? 3, maybe more. Are they lying to you? Probably not. They're your colleagues. So, but they took away different things out of the meeting, understandably so. That's true in any oral discussion. And that's why I say, don't do it. Put it in writing. So we're going to go through this pretty fast. So month-to-month agreements are basically renewed every 30 days, at least for a term, typically 6 months, but more likely a year. All right. If you look at the benefits and the detriments under each point, you will notice that they are the opposite of one another. You can't have both. In a month-to-month agreement, what you are bargaining for is flexibility. What you don't get then as a result are guarantees, either in price stability for the tenant or a long-term agreement for the landlord that creates stability in rent. So for at least for a term, it's just the opposite. So you get the stability, you don't get the flexibility. If either side wants out, they have to get the agreement of the other side, or there has to be a breach of the agreement by either side. One side simply can't say, you know what, I don't like this, it's not working, we're done here. That's a month-to-month agreement. 30 days, don't need a reason, you're done.
Joe, can I jump in real quick?
Sure.
Question, should house rules be put in the lease?
If they are not, they should be referenced in the lease saying that the house rules are incorporated as part of the lease. So it's understood that they work together.
And of course, house rules should be written and signed.
Absolutely.
Yeah.
Absolutely.
And one more, if the
If you go to,
facility is a,
if you go to court and you have a house rule that's not written down, that's even worse than an oral lease agreement. A court is just going to hate you that you didn't bother to take the time and the energy to do it in a workmanlike and businesslike fashion and put it in writing. They are definitely going to hold that against you.
one more, if the facility is accredited through COA, they must follow landlord tenant laws? That's a question.
I don't know what COA is.
Yeah, I asked for clarification on that. I'm trying to understand exclusion versus inclusion.
All right, so back to where I was before. I said there's a list of exclusions that do where landlord tenant law doesn't apply to these types of residential premises. There is no exemption in Ohio law listed for recovery housing. So, as a rule of statutory construction, if you are not on the list of exemptions, you are not exempted. Therefore, you are included within landlord tenant law, and landlord tenant law applies to you. I
Good,
know
thank you.
I kind of said that again. I don't know how else to say it to make it more comprehensible.
That's it for questions for now. Thank you.
Okay. All right. Prohibited terms. I won't have them all here. I have most of them to give you some idea. So these are terms that if they're in the rental agreement, it doesn't matter. They're not enforceable. All right. Simply stated, the law trumps the lease. Not sometimes, not most of the time, all of the time. All right. And you'll see that I have shifting landlord duties to tenant bolded because that's, in my opinion, the term I see most often in rental agreements that's simply not enforceable. A landlord simply can't say, but it's in my lease. The answer is, for me, I don't care. The law says differently. So you don't get to write yourself out of the law through the lease. I probably should now be bolding indemnification. That's where a lease says, if I do anything or the property in any way causes harm to the tenant, you agree to shield me from any liability or legal harm. You can put it in your lease, you can't enforce it. It's simply unenforceable under Ohio law. Likewise with self-help evictions. You have to go to court to evict. Doesn't matter if you have a provision that says, no, I don't have to, because yes, you do. It's not enforceable. We'll talk more about that in part 2. Hopefully we'll get a chance to get to that. All right. More broadly, a rental agreement term that is bad, or in this case is called unconscionable. That's because those of us in the law never use a small word when a big word will do, like unconscionable. Basically means unfair or illegal. So if it gets to court and there's a question of whether a particular term is enforceable or anything, a court may refuse to enforce either the entire agreement or that particular provision because it is unconscionable. It is not typical that this is used in courts. I've only used it a couple of times in my long legal aid career. All right. There is no definition of unconscionable. What does that mean? There is no certainty. All right. There is no way of knowing whether a particular term is enforceable or unconscionable until you get to court and the argument is made. That means for both sides, there is risk, there is uncertainty. Usually what accompanies risk and uncertainty are things like court actions, lawyers, legal fees, money. Those are all things that if you're not a lawyer, people seek to avoid for good reason. Therefore, there's a lot of incentive to avoid having to deal with the question of whether a particular term is enforceable by either landlords or tenants. It has been used in Ohio on numerous occasions to attack late fees. Not the question of if a late fee is unconscionable, but the amount. So unreasonable late fees can be deemed unconscionable by a court. So, and in different places, you will get different results about how much is too much in order to call it unconscionable. I will tell you that as a standard matter, late fees that are per day will be considered unconscionable. If we have time, we'll talk more about that later in part 2. All right, duties of landlords and tenants. So I'm not going to, again, read these to you. You pretty much find them all in 2 separate consecutive statutes under the Ohio Revised Code 5321. What I want you to look at as I put them up on the screen is to see the parallels between the landlord duties and the tenant duties. A lot of these are what codified what was called common law in 1974 when the Ohio Landlord Tenant Act was passed. Again, notice the parallels. Both landlords and tenants have duties about the same things. I want to spend a moment about what I bolded there. You do not have a duty to supply appliances. You should specify that in the rental agreement. However, once you do supply them, you can't say, oh, you know what? That's expensive. I'm not going to replace it. You go replace it. Once you put them there and they're part of the agreement, nope. You can put them there and say, I'm not responsible for them, but that means you're giving them to the tenant. An example I can give you, the last time I rented, my place was not air conditioned as a unit. There was a room air conditioner. In my lease, it specifically said, we are not responsible for the air conditioner. If the air conditioner breaks, or needs maintenance, don't call us. We are not going to help you. You do with it what you want. If you want to throw it out, throw it out. If you want to keep it and use it, feel free. If it fails, it's your job to figure out how to fix it, not ours. We wash our hands of it. And that's how it should be with all appliances that are left but are intended by a landlord not to be maintained by the landlord. More duties. All right. We will spend some time talking about housing codes a little bit later when we come to rooming houses. All right. But again, housing codes in cities can cite both landlords and tenants. We'll talk more about damaging a little bit later. Oops. Got my cursor on. We'll talk more about entry at the beginning of part 2. All right. So, evict tenants when they have actual knowledge of drug activity. So, John, if I put this up to the screen, can people see can people see?
Not very clear.
I do this, does it help?
Yeah,
All right. So,
barely.
if you see down here at the bottom, the last 5 lines or so, starts the definition of actual knowledge. On the next page, it continues in a total of 2 sentences with that entire paragraph. 2 of the longest, most convoluted, poorly drafted sentences in the history of statutory construction, in my opinion. Does that mean that tenants don't get evicted for drug activity? No. It's just that landlords, tenants, and courts pretty much ignore all of this language. Anybody who says to you, I know what actual knowledge means under Ohio landlord tenant law, in my opinion, is almost certainly lying through their teeth. They have not memorized this language. So it's just too damn difficult. So what does it mean for a tenant? So they have to comply with drug laws too. Or, as I quote Nancy Reagan, for those of you old enough to remember, just say no. All right, more duties. As a landlord, you have to supply running water, hot water, heat. The duty to supply does not mean to pay for. I've been getting those questions a lot lately. What does it say about paying for water under landlord tenant law? It doesn't say anything. Multiple cases have been brought trying to convince courts that given the other context of this statute, that supply should mean the landlord must pay for. Courts have routinely struck down that interpretation and say, no, it means there's got to be pipes. They have to be responsible for making sure the pipes work, that there's faucets, that there's a hookup. They're responsible for all that. That's what supply means, nothing more. So tenants have a duty to not damage the premises and keep their guests from it. So for example, and again, I've heard this before, a tenant can't disclaim responsibility by saying, well, I didn't do that. My guests do that. You can't hold me responsible. Absolutely. A landlord can hold a tenant responsible. It was your guest. You're responsible for your guest behavior. Sorry. All right. Same thing with your guests causing noise. It's your job to make sure your guests don't disturb others. Now, does that mean the tenant has to play bouncer? No. It's their job to tell the guests to sit down, shut up, be quiet. If they don't, it's their job to call the cops and have the cops escort them out of there. All right, so before we get to this next piece, are there any questions about duties that we've talked about so far?
Joe, we got a question. So a nonprofit recovery home, uh, if they're nonprofit, I guess that means 503c. They're exempt or they're not exempt?
Again, you have to follow you have to be a 501c3 It doesn't necessarily make you a nonprofit, and you have to be a single room occupancy facility.
Okay, that's it for questions. And just to point to everybody out that Joe's PowerPoints are in the handout section, so you can download that if you like. Thank
Again,
you.
in my opinion, from what I know, you will not, if you're looking for help from Ohio Recovery Housing or OMOS, they will not help you because they want you to follow landlord tenant law. I know OMOS has money for recovery housing providers. If you're going to tell them I don't have to follow landlord tenant law, they're going to say, go find your money someplace else, from what I understand. All right, retaliation versus discrimination. Two distinctly different things that people use interchangeably when in fact they are not interchangeable whatsoever. Almost never do the definitions of these terms overlap. Retaliation is defined by Ohio landlord tenant law, and one of the few places where landlord tenant law is very specific. Discrimination is defined by fair housing law. First, retaliation. So a landlord commits retaliation when they increase rent, decrease services, or try to evict. When the tenant does one of these three things: they complain to a government agency, they complain to the landlord about things that aren't done, like conditions usually. They try to organize tenants to negotiate. So typically, it's when a landlord tries to terminate, all right, when the tenant does one of these things, most often complain to the landlord or government agency about conditions issues that the landlord refuses to rectify. So retaliation, if shown by the tenant, is a complete defense to an eviction. Now, discrimination is defined by the Fair Housing Act. So it's much broader, much more ambiguous. You should know Ohio also has its own version of the federal Fair Housing Act. All right. And it applies to rental properties. So all rental properties, not just those governed by HUD. You will see the list of what is called protected classes there. And if we had more time and we're doing fair housing, I would spend a lot of time talking about that. But we are not here to do fair housing, and I do not have a lot of time. It's basically when a landlord treats someone differently and adversely because of their membership in a protected class, not just because they happen to be a member. You will see Ohio adds 2 other protected classes in addition to the 7 under federal law. All right. Fair housing requirements will apply to you one way or another. You can't escape it. As I said, all right, the Fair Housing Act is broader. It almost certainly applies to you, even if you say that landlord tenant law does not. If somehow the Fair Housing Act does not apply, almost certainly the Americans with Disabilities Act, or ADA, applies, which is a separate fair housing provision that applies to public accommodations. You have to either be in rental housing or a public accommodation. You can't be in a space where you say, well, I'm not either of those things. I'm my own thing. No laws apply to me. So good luck with that in court by saying, I'm in my own space, so I can do what I want. No laws apply to me. I don't see that happening. I don't even see you finding a lawyer who's going to be willing to make that argument for you. Because most lawyers I know, including myself, when they go to court, do you know what they like? They like to win. They don't like being given an argument by their client saying, do it this way and win, knowing that they can't. So understand that disability includes substance abuse. Disability is a protected class. Disabled means current alcohol users. When it comes to controlled substances that are illegal, it means formerly using controlled substances. So even as an alcoholic, you can be a current user, still be considered disabled, and still be entitled to request a reasonable accommodation under the Fair Housing Act. So often that means, like, I want a second chance. The other piece that's important for you to know is that you don't get to have a blanket ban on pets without allowing reasonable accommodations. Essentially, assistance animals, which are defined differently under the FHA versus the ADA, but we don't have time to go into all of that today, are simply no longer pets under FHA or ADA, and pet rules don't apply because they are not pets. So these are the types of reasonable accommodation requests that are kind of things that are suggested. You should know that when I was developing this PowerPoint years ago, I worked on this with Lori Chris. I don't know if you folks know who Lori Chris is. Lori Chris is now the director of OMOS, appointed by Governor DeWine. She came from Ohio Recovery Housing, where she was a director, and she wanted me to talk about this with recovery housing providers as things that they should consider doing. So, as a way to try to avoid evictions. You should understand you are not required to do this under Ohio law. These are just suggestions to try to make things work better for everybody. So, and I agreed with Lori, and so we put all this stuff in. You'll see this recounted again, assuming we have time to get to the termination process. All right. Rooming houses. The first and foremost thing is rooming houses are not a term under state law. State law does not speak to this. You must look to your local housing codes to determine if and how rooming houses are defined in your neck of the woods. All right. I'm going to give you examples from 3 localities. Notice they're all big cities that define rooming houses. All right. Cleveland, for example, has nothing about rooming houses. There is no regulatory scheme in Cleveland. So I can't tell you. If you're going to ask me about other places, I'm not going to know off the top of my head. There are hundreds, if not thousands, of localities that develop their own rules. I consider myself good. I'm not that good that I have them all memorized. All right, Toledo. All right. Notice you'll see things in common among these, and I'll point them out. All right. So you have to have a rooming house permit. Notice up above, a dwelling containing 3 or more units. You will see as commonality factors going forward in the 3 cities I give you that it's 3 as a minimum, and there's some kind of permit, certification, licensing requirement that's done by the city in order to approve your place as a rooming house. And you must do it if you operate in that sense in order to be deemed appropriate in the particular location that you're working in. So again, we're not going to go through all of these. This is here for your ability to take a look at and see if it applies to where you operate. So again, notice in Cincinnati in the first sentence, occupied by 3. Notice the second section talks about licensing or certificate and posting. Columbus, all right, again, notice how it says in line 3, 3 is the number. All right, and that licensing is required in Columbus in order for you to properly operate a rooming house. So the William Brady organization, this came up in the Columbus Dispatch while I was at one point when I was doing one of these presentations. I thought, perfect, an example. So there were 9 places that they ran. So they didn't go to Columbus and say, hey, what do I need to do to be able to run rooming houses? One of the tenants called them, said, hey, we have problems. The city came out and inspected what is called the Office of Code Enforcement that enforces the city housing code. They said, we ain't going to license these places until you guys get your act together. All right, set this ship straight. So they had been in business for like 8, 9 years, serving all these people. They just never checked. So just so you understand, in Columbus, all right, in Columbus, there's a housing code. Does Columbus code enforcement believe that the housing code applies to you as a recovery housing operator? You betcha. Good luck arguing that the housing code doesn't apply to us because we're not really housing and we're not really landlords and tenants. That's an argument I think you will lose every time. And here, if you're really, really a bad actor, you can draw the attention of the Ohio Attorney General, who will probably shut you down. Notice in the second bullet point, they said, we are done with you. We want the court to appoint a receiver, which means the receiver will take over running the entire operation, which is what happened. This guy that ran Summer Rays was out of control. So Kirk just, he was, I don't know. He basically, in my opinion, was running a cult. If you look at the last bullet point on the second piece, where it talks, there was places that lacked heat, air conditioning, running water, and electricity. Like he could go do all this because he ran the show. No, that's not how it works. So the state said, you're done. You are out of here. We are done with you. So we're taking over. So be careful on how far you might want to go. Again, he ran a sober house. So we are done with part one, all right, where we did definitions, talked about rental agreements, duties, a little retaliation versus discrimination, defining and reasonable accommodations. So now again, John, is a good place to stop before we continue with
Sure.
part two.
We got some questions.
Good.
How do we navigate applicants who have sexual offenses on their record?
So they're the only type of those that have sexual offenses that you're not allowed to entertain are type 3, tier 3 sex offenders, which means lifetime ban, and only if you're within 1,500 feet of a place where there's kids, like schools or daycare centers or things like that. So if there are certain types of tier 2 offenders that may also fit into the tier 3 category, but only if the local authorities deem them dangerous to neighbors. And if so, it is the duty of local authorities to contact the person housing the sexual predator that they believe, although not type 3, but type 2, is still too dangerous to be allowed to live at the premises. So that's a very case by case, locality by locality determination. But other than that, you are permitted to house sex offenders. You, of course, can decide not to house sex offenders as long as you apply that kind of screening criteria across the board evenly to all.
Next question. If your recovery home is only for either males or females, but not both, can they claim discrimination based on gender? I know that seems like a crazy question, but I worked at a treatment center in Cleveland. If we didn't have the bed they needed, they claim identification to the gender to those that had open bed.
That's actually at least two questions there, maybe more. I'm going to get to the straight man versus woman. So is that sex discrimination? Yes. So if you're going to do that, you're going to have a reason as to why it's necessary. The reason can't be, well, that's how we've always done it. That's not a reason. So when I talk to shelters, I always tell them, you have to have a basis about why it's not possible to have both of them in the same place. This is easier if it's a shelter for domestic violence victims, where they may still be traumatized by acts committed by males. So after that, it would be pretty hard to justify. I do not know what justification a recovery housing provider would have to serve only one sex but not the other, off the top of my head. That doesn't really make sense to me under fair housing law. When you get to gender stuff, I will tell you that makes it a lot more complicated. And if the person identifies themselves as different than the biological sex than they're born with, and you disagree, you are probably going to be asking for a fight. HUD basically has said, when it comes to this kind of stuff, the person gets to decide what they are, not the housing provider. And so the question then becomes whether anybody takes that to court. These are fairly new rules. There's not a lot of court cases. There's not a lot of outcomes. So it's basically, how much of a fight do you or the transgender applicant want to put up for something like that? There is no real black and white answer here, which I know is what you are seeking.
Um, is a landlord required to do background checks on tenants?
Not at all. However, I would warn you that if you do it for some, but not for others, you run into danger of, why did you select this person for a background check and not another? If they end up, even if you didn't intend it to be members of a protected class as a group, you could get sued for violating the Fair Housing Act, because you don't have to intentionally discriminate. If you end up discriminating subliminally, because by choice, these people you sought to screen and these other people you didn't, and it turns out these people are all Muslim, or these people are all of a certain national origin, then you may have trouble. Because you can't say, well, that wasn't my intent. That may be true. What that will do is maybe save you from greater liability, but it won't save you from being liable. Because if it turns out that it shows that you have a practice of screening only certain types that fall into a protected class, it's not a question of if you are liable, but how much you are liable for.
Can you have the applicant pay for the background check?
Yes, again, as long as you do it for everybody. We'll talk about that, and that's part of section 2 as well. I'll delve into that a little bit more, because it looks like we should have some time to get to that space at this time.
Yeah, and let's see here. Um, can you question on your housing application that asks if the person is a registered sex offender?
Yes, again, as long as you're applying it to all equally.
The application is part of determining if the person is appropriate fit and also level of care. Okay, that's just the same thing. Um, are housing operators allowed not to, let me just say that again. Are housing operators allowed let's just summarize that. Can you deny residency to violent offenders in a level 3 recovering home? So you do a background check, you see that he's has violent criminality.
Again, as long as you apply the standard equally to all.
That's it for now.
So, and again, we're talking about, I assume, those that were convicted of a violent offense, not arrested. HUD has made very clear that arrest records are not considered to be substantial evidence or enough evidence to screen people out, because it turns out that there is a lot of discrimination by police when it comes to arrest. That Black and Hispanic people are disproportionately arrested with not any ever crime either being indicted or convicted of. And if you used arrest records as a basis, you're going to get yourself in trouble. You need conviction records.
And as long as you apply that across the board to all applicants, you should be good.
Exactly. That's correct, John.
Okay, that's it for now.
Okay. So we are done with part 1. On to part 2. The first one, which is usually another place where everybody likes to ask questions: entry and access. So landlords and tenants both have duties in this regard. So as a landlord, you have to give 24 hours notice that you are going to enter unless it's an emergency. A tenant must permit the landlord to enter upon getting 24-hour notice. And they can't say, and I get this a lot, well, I'm not going to be there. So what? Your presence isn't required. Well, I don't want them to come in at that time. So what? You don't get to decide or permit when the landlord enters, as long as the landlord gives you a proper 24-hour notice. So it has to also be for a proper purpose. So like this here are some examples of proper purpose. There's an exception for emergencies. Emergencies are not defined. I will tell you that, in my opinion, trying to walk past the unit and go, I smell something funny. I think we have an emergency. I'm going to go in and take a look. I don't think that will fly. All right. It's understandable for you to have rules about that, or there's a little noise in there. I wonder if they're drinking alcohol. I think this is an emergency. As doing recovery housing, you have a right to enforce rules like that. All right. But you don't have a right to simply barge in anytime you want. Again, those rules would be considered reasonable. All right. They wouldn't be considered reasonable if you were not a recovery housing provider. You're just an ordinary landlord. Having rules barring alcohol consumption in the unit, that would be unconscionable. That's not true for you guys. But you don't get to enforce them any which way you want or however you think you should go about doing it. There are rules about this. 24 hours notice. All right. As I said, reasonable is not defined. So, again, the statute's specific when it comes to the 24-hour notice. All right. Other things to think about when considering reasonable. You should know. You should announce your presence. Timing can be negotiated, but it doesn't have to be. But timing, again, is part of reasonableness. Is entering at 11 o'clock at night reasonable? Not in my opinion. Can I cite you any case law about that? No. But I dare you to find me someone who says, oh yeah, going at 11 o'clock at night into somebody's personal room or residence, that's reasonable, that's not late. Same thing, how early is too early? I just had this discussion with somebody. I said, she was talking about 7 o'clock in the morning. I said, that's too early. She said, well, they probably won't come until 9. I go, that's probably going to be reasonable. Again, not defined. A little talk about this. I have talked to 2 people, one just recently and one a little while ago. And here's the problems you might encounter if you don't knock or announce your presence. This happened in both cases. They got a 24-hour notice. So they knew they were coming. Both times it was early in the morning. So the tenant wasn't aware they were entering. They were in the bedroom. The door was closed. They were taking a shower. They got out of the shower. They were getting dressed. The maintenance person then opened the door to the bedroom. And oops, you're naked. Is that a specific violation of landlord-tenant law? No. What do you think about an invasion of privacy? I think you betcha. So I think that's a good way to get sued, and not just for landlord-tenant law, but for an invasion of privacy. Pretty sure those are facts. As a housing provider, you do not want your lawyer to have to defend by saying, well, we gave them 24-hour notice. They shouldn't have been naked, even though we didn't say that, we didn't tell them when we were coming and that we were there. Not good facts. As I said, purpose and time of day must be reasonable. I can give you a war story as an example of this. So we were in court. I was defending an eviction. I told the landlord, I don't think you can win this. Here's why. This is what I'm going to tell the court. But we don't want to have to do this all over again. We're willing to make a deal to move out since she's not very happy with you and doesn't really want to stay. And they looked at me and said, I ain't making no deal with you. So I'm going to get them out, and I'm going to get them out today. I said, okay. Went into court. I made my argument. The court said, yep, you can't do that. Case dismissed. As you might imagine, he was pissed. Went out in the hall and he said, so here's what I'm going to do. I am going to go over to the place right now and give a 24-hour notice to come in tomorrow. And when I come in tomorrow, when I leave, I'm going to give her another 24-hour notice to come in the next day. And then when I come in that day, I'm going to give her another 24 hours notice to come in the day after that. And I turned to my client and said very loudly, okay, when you get 3 or 4 of these, I want you to save them all. I want you to call me. We'll set up a meeting. We'll come to my office. I will collect them all. I will attach them to a complaint and a motion to the court to forbid the landlord to enter anymore because he's abusing. There is no purpose. It is just to harass, which is clearly not a purpose under Ohio law. The landlord, having learned his lesson in court just before, decided maybe he shouldn't test me once again about my knowledge of landlord-tenant law, and that never happened. But I'm going to stop here again, John, to see if we have questions about entry.
We do have questions.
There's a shocker.
Can a landlord conduct random room searches if it's part of the agreement? If the agreement says alcohol, if part of the agreement states must be alcohol and drug, the premises should be alcohol and drug free, and no substances on the premise.
I assume that this question comes with the idea that you don't have to give 24-hour notice to your random inspection. The answer is no. No, no, no. This goes back to what I said before. Your lease cannot define you out of the requirements of landlord-tenant law. Your lease is in direct conflict with the 24-hour notice provision of landlord-tenant law. Remember what I said previously? When it comes to a conflict between a lease and the law doesn't win some of the time. It doesn't win most of the time. It wins every time. Because think about this. If a lease could define what a landlord can do, landlords would put in the lease everything that is defined as unenforceable under landlord tenant law, and landlord tenant law would become unenforceable. It would become useless. The idea of law is that it's supposed to be interpreted in a way that the provisions have effect, have meaning. Doing this does just the opposite, because a landlord simply could define themselves in a way to make all of the requirements of landlord tenant law not apply to them because they put it in the lease. That's not how it works, just the opposite.
Is the entry notice, can the entry notice be in writing, verbal, text, or email?
So it can be in any of those forms. In my opinion, you are a fool if you do not put it in some form of writing. You have simply no proof that you gave 24 hours notice if you just say so. What do courts like? They like proof. Is your testimony proof? Sure. Is the tenant going to agree that you gave? Probably not. So that's why courts want to see a writing. Text, emails, paper, they all count. It can be written on the back of a napkin. Is that wise? No, but the law doesn't require people to be wise.
So you send an email to your tenant saying, giving 24-hour notice, but you don't have a reply, but you did. So how does that square?
Well, it's just like if you were to post a notice on a door. Uh, it's not required that they see the notice in order for it to be effect, because any tenant could simply say, well, I never saw it, so you can't come in. That's too easy a circumvention for the tenant. So that wouldn't be permitted. All right. You might want to do, if you do an email, a way where you get notice that they've opened the email so that you know that they've seen it. Not required, just a suggestion.
And so we do not allow smoking on the property, and smell cigarette smoke coming from a unit. We cannot knock and ask to enter.
You can ask to enter, you can't mandate entry. And you are allowed to have no smoking rules. Those can be enforceable.
What if you don't have contact with a person in your recovery house for a period of time? Do you have to give notice of entry? So you don't have contact with a person in your recovery house for a
Yeah.
period of time.
I tell that to any landlord. If you're not sure they're there, post a 24-hour notice that you're going to enter to figure out if they're there or not. It's really that simple, in my opinion.
That's it for now.
Okay. All right. As promised earlier, a little bit about stuff not included in Chapter 5321. Rent increases. So how much or how often? Not regulated. Just can't do it in the middle of the lease without certain kind of provisions. There's are ways to do it, but you can't lock a person into a year's lease and then say, I can raise the rent anytime I want in the middle of the lease, and there's nothing you can do about it other than pay it. That would be considered, in my opinion, unconscionable. Late fees. Late fees, as I said, are not defined. They don't have a limit other than the limit of unconscionability that we talked about earlier under Revised Code 532114, which again isn't known until you get to court and one argues that it's too much and therefore it's unconscionable. But a reasonable late fee is clearly permissible under the law. Application fees. You can look far and wide and high and low, and you will not find this term anywhere in landlord tenant law. In a lot of other states, you will see this term. You will see it defined. You will see it limit the amount. Not in Ohio. We're not that prescient. So we have seen no reason, for whatever reason, to enter that. So yes, you can. All right. And again, you just have to apply your fee to everyone equally. A deposit to hold a unit. In my humble opinion, this is not a security deposit. There are plenty of people who disagree with me. Why do I say it's not a security deposit? Because holding the unit is not a deposit that is used to secure performance under a lease, which is the definition of security deposit. All right, because there has been no lease yet. There's no performance yet. So what I do encourage you to do is if there is a deposit to hold the unit, you put it in writing. You say what unit it is. You say when the unit will be available. You say what happens when the unit is not available, what the expectations are for both sides, when the landlord gets to keep it if things go south, when the tenant gets to request it back if tenants go south, and to be very specific about that. Almost never are deposits to hold units defined by contract, which is where they should be defined by landlords. I have that lecture to landlords and tenants all the time. All right, so talks about security deposits, which wait till next screen, we will talk about more. And there's no limit on amount, contrary to popular misrepresentation. All right, as I've already discussed, and I hammer home, the limit on late fees is they can't be unconscionable by whatever amount a court determines. You should understand that late fees under contract law are considered to be a fee to hold the landlord harmless for the harm the landlord incurs as a result of getting the money late. The administrative issues that arise because they have to go take more action to collect the fee. It is not supposed to be punishment for paying late because contract law does not include punishment as a reasonable part of contract law, and a lease is a contract. Therefore, contract law principles apply. So here we go about the no limit on amount and why it is popularly believed that it's 1 month. If you charge more than 1 month's rent, all right, then there is to be calculated 5% annual difference on the amount of difference between the monthly rent and the amount of deposit that starts after 6 months of tenure. Who wants to do all of that math? Right. It's a rhetorical question. Hopefully you got it all right. So that's why landlords typically settle in at 1 month's rent to avoid having to deal with this provision of the security deposit law. So when tenants leave, a landlord has 30 days to return the deposit. All right. So leaving means the tenant must move out. The tenant must move out all of their stuff. They have to return the keys. They have to give you a forwarding address. When all four things have happened, the 30 days starts ticking. So landlords then have to itemize deductions and charges if they want to keep any portion of the security deposit. All right. If a landlord keeps the security deposit and the tenant believes it should be returned to them, all right, the tenant can sue the landlord for the amount they believe should have been returned for them. If the court agrees, the court is supposed to automatically double what was withheld wrongfully that the landlord should have returned. If a tenant manages to get an attorney, they can also collect reasonable attorney's fees for this. And that's happened. There's a case out of Ohio State where they tagged him with a lawyer where a landlord was being particularly obnoxious, failed to return it, obstructed the going forward with the case along the way, failed to show up for court, made people keep coming back. The lawyers for the tenant kept coming back. They kept racking up fees. They racked up $12,000 in attorney's fees as a result for something like a $500 security deposit that was doubled. You should also know that if you fail to follow the 30-day requirement, there's really no penalty for you. So, unfortunately, which has also been litigated many times, and therefore is a provision that has no teeth. All right. Any questions about security deposits before we move on to termination?
Yes, if you have a deposit to hold the unit, but doesn't put the unit number on it, then keeps changing it. I imagine the unit, they keep changing the unit around, um, and then keeps changing it, and then states they will keep the deposit. Is that enforceable? So I'm imagining what it is I want to hold on unit 3, and then they switch it. Well, it's for unit 4, and the tenant says, I wanted unit 3. Is that enforceable?
Won't know until you get into a court. Is that a case back when I was a legal aid attorney that I'd be willing to take for the tenant? You betcha. So especially if you showed a unit and then you switched it up. So whose fault is it that it wasn't clearly identified? You already know the answer to that question. So you can't keep playing around and switching it around and then say, you'll take whatever I give you, because that's essentially where you're landing with this. I'll take that case every time.
Mhm.
Will I win? I don't know, but I'm more than willing to give you a hassle about it for playing that game. I don't think you should play that game. I think you should be specific. And if you can't deliver that and the tenant, that's what they want, they should be entitled to keep their money.
That's it
It's
for
too
now.
easy for a landlord, especially if they're showing it and saying it, but not putting in it, to ultimately decide, I don't really want to rent to this tenant. So what I'll do is offer them a different unit, and they won't like it, and they'll say no, and then I'll get to keep their money and not have to rent to them too. What a great idea.
Yeah. Yeah. And of course, everything, get it in writing and be specific.
Couldn't have said it better myself, John.
Yeah.
Are you sure you didn't go
That's,
to law school?
I've, we'll talk about that another day.
Gotcha. Look forward to that conversation.
Yeah. Okay. Well,
All
let's see. I just I got to clarify. Wasn't. Oh, never mind. No more questions
all
at
right.
this time.
This is probably the last section we'll be able to cover. Termination and eviction. So termination is when you give a notice saying we are done renting to you. All right, either at the end of the lease term or as a month-to-month tenant, 30 days notice. If you're a month-to-month tenant, you gave a notice today, it wouldn't be effective 30 days from now. It would be effective for the end of February. The tenant still has to pay rent for February. You don't have to give a reason. All right, that's required under the section of the law you see there. A termination or an eviction is under a different chapter of law, as you may remember from the very beginning. So there are many reasons a landlord can bring an eviction. I give you 3 here of the most common. This is not by any means the exclusive list. There are many others. This probably comprises at least 95% of the reasons landlord bring evictions. Again, this was a slide developed with a conversation between me and Lori Chris, who I mentioned earlier. So we basically stole from HUD's administrative due process procedures and said, if you're going to create an administrative due process, here is a good way to do it. State the reason specifically. Give them a right to meet with you. Give them a right to bring somebody with them. Have the person who has the meeting be somebody different than the person who made the decision, right? And not a subordinate to the person who made the original decision. So it's more independent. Again, you are not required to do this under landlord tenant law. That is just ideas about how to make the process work better for all in the minds of me and recovery housing and now OMAS. All right, you can think of the eviction process as a 4-stage event. Something happened that create termination. You have to give a notice, which we'll talk about next. Then you have to go to court, and then there's a hearing. So you have to serve what is called a 3-day notice or notice to leave premises. That's under the section of law you see above. That notice must contain this language. When I say magic language, that's my term. That is not a statutory term. Why do I call it magic? If you have a notice and it doesn't have this language, and the court asks you for a copy of your notice to vacate, and you don't have that language on that, you lose. Doesn't matter what the reason is you're evicting. It doesn't matter if the tenant's not there. You have not met the requirements under eviction law. It has to include this. It is what is called jurisdictional. That means there's no ifs, ands, or buts. You have to do it. If it's not there, you lose no matter what. So you have to wait 3 days before you can then file. This language up above, often you will see in the note, and you'll see it in the notice I provide next. It's often bolded, boxed, and capitalized to make it conspicuous. Do you count Saturdays, Sundays, and holidays? Well, you know what? That comes under that great lawyer answer called, it depends. What does it depend on? Depends on where you are. So it's basically an interpretation of an Ohio civil rule. I won't go into detail. Some courts say, no, you don't count Saturdays, Sundays, and holidays. Some courts say, yes, you can. So more courts, by about a 15-5 or 20-5 margin, say, nope, can't include Saturdays, Sundays, and holidays. About 5 courts say you can. There's over 150 municipal courts in Ohio. What does that mean? Most of them have not spoken to this issue. Most will tell you that if confronted with this issue, they probably would not include Saturdays, Sundays, and holidays. So to be on the safe side, you should not. But that's up to you. Oh, shoot. I think I pulled up the wrong. I'll have to give you I think I pulled up the wrong one. Sorry, John, it doesn't have a copy of the notice. It will be in the one that I hopefully gave John yesterday. If not, I'll have to take it back and look. There was a copy of a 3-day notice in the final presentation. It looks like I pulled up the wrong one. I apologize. All right. You should understand that evictions are what I call.
Joe, if you send it to me, I'll be happy to forward it on to our attendees.
Yeah. My bad. I could have sworn I even pulled it up and looked at it. I don't know what happened. Nothing can ever go 100% right. So there's special service in landlord tenant cases, what we call nail and mail, different than service in all other types of cases. So service is accomplished by posting at the door in first-class mail. Others is a more complicated procedure. Again, hearings are scheduled, again, by local rule. These are 2 examples from places that I've dealt with a lot, mostly Franklin County. You should understand that local rules determine when the hearings are scheduled. There are, again, 150 plus local rules. There are some courts that take a month to schedule these. You have to look at your local rules to know how long it takes to schedule. So often landlords file for both like unpaid rent as well as possession. We'll talk about that momentarily. So you file with your local court where the property is located. They'll schedule a hearing. They'll send it to the tenant. They'll send you a notice. The first cause, or the claim for possession, all right, is about who gets control of the property now. The second cause, if one is filed, which is a claim for money, often is heard at a different time. If it's about non-payment, here's how I seek to differentiate them. If it's non-payment, although they're related, the question for the court in the first clause is money owed or not at the time of filing? It's a yes or no question, up or down. The second, it's not about amount. In the second clause, the question is, how much is owed, if anything? That's where the how much question is answered. Not. Typically at the first cause of action, which again is typically not done at the same time, because the first clause is a different proceeding under law, under like the second claim, which is a contract clause claim and must follow other civil rules. If you win as a landlord, you get to remove the tenant's belongings by what is called a writ of restitution. Excuse me. We'll talk a little bit about those. So in the big cities, there are evictions every day. Magistrates hearing. The tenant loses. In Hamilton County, a 7-day writ is issued. In Franklin County, a 5-day writ is issued. You typically have to go pay for that. In other counties, it can be shorter or longer. In some counties, there is no local rule. So what's the rule? It's whatever the judge says how long it is rule. So they can make it up as they go along. Self-help evictions. The answer to this is you can't do it, you can't do it, you can't do it. Again, if you put it in your lease, it doesn't matter. The law prohibits it. Remember, law trumps lease all of the time. You can't do any of these things without going to court. Any of these things are a violation of this statute. If you violate this statute, then a tenant can sue you, and you can be liable for damages or attorney's fees. It's one of the places where tenants can collect attorney's fees, and subject to injunctive relief. What does that mean? That means an order from the court. If you've locked the tenant out, an order from the court to let the tenant back in, give the tenant the keys, don't come back and lock them out until you've gone to court and received permission from a court to be able to come in and take over. All right, we have to end there. I know we're just over time, so I'm not going to go through the rest of the stuff here, but I'll entertain any questions if people want to remain about what we talked about with evictions or anything else. I will also advance it to the end, which we get just to be able to see the resources and my contact information. But John, if you have any questions still, I'm happy to take them now.
Yeah, I've got one more question, and everybody that's still on, we still got a couple dozen folks still here. I did make a PDF of the 3-day notice that I have that you sent me, and it's now in the handout section of the webinar.
Okay,
so you can download it now, as well as Joe's a PDF of his PowerPoint presentation.
So John, was the notice in the PowerPoint that I sent you yesterday?
Yes, it was.
And that's the one you posted to the group, right?
Yes.
All right, so they will have it even though it wasn't up on the screen today.
Right, and I'll reach out to everybody anyway, because we have a post-training survey that'll come shortly, and I'll include that as an attachment to it. Is there any recommendations for somebody finding a sample lease that they can model after?
So we do not have sample leases. We actually just found one that was, when a landlord asked this question, that the Franklin County Law Library put out. Again, we have not screened it. We are not recommending it, but they're pretty good at their job. So that might be a place for you to go look. You should also know that the Columbus Apartment Association, which actually serves all of Ohio, not just Columbus. There used to be a piece of it called the Ohio Apartment Association, also has lease templates. which I believe are free for members, but you can probably contact the Columbus Apartment Association and for a fee, get their template that they recommend that landlords use. Years and years and years ago, in another lifetime, I actually was part of a group that helped create this template. So I know it has, provisions I don't like. I also know it has provisions I do like, and I know that what I consider to be the most onerous or tenant unfriendly provisions were removed. How much that may have changed over the years, I don't know, since I have not looked at it in some time.
That's it for the questions. I got a lot of comments saying thank you, very informative, great presentation, learned a lot. I learned a lot because I'm a small business landlord myself, and I
Good.
appreciate the information. And you are presenting at the ORH's annual conference coming up in March. So
Yeah,
anybody,
I know you said you have to get me some kind of unblocked to allow me to register and stuff.
yeah,
I
yeah.
also haven't seen a specific time or amount of time or anything yet. I assume you guys are still working on
Yeah, we're still massaging that schedule. So
that. Yeah. I think I
yeah,
blocked off the date or the 2 dates for it, so I'll just make sure I won't put anything else in there and keep that.
yeah. And I invite our listeners, if on March 8th and 9th is the ORH annual conference, and I think Joe is on the 9th. I don't know, but
But that
that
sounds
information will
good.
come down the pike.
Right.
And getting a
You,
lot of thank yous on our website, and I
you're
thank
welcome.
you.
Yeah, I mean, if folks come, you will largely see this same thing because the law won't change much in 2 months.
Yeah,
However, I also tell you that, in my opinion, it's a much better and more fun presentation in person. So,
yeah, great.
whatever. And most
Okay,
important, Don, I still have a voice.
you're still hanging on.
And that's important because I wasn't absolutely certain.
Yeah, yeah.
It's not
We
100%, but it's still working.
yeah, we came close to postponing this presentation, but I'm glad we got her done.
Me too. Me too.
Okay. All right, everybody. I'm going to end the webinar now, and I'll be reaching out to you with a post-training survey shortly. Thanks,
All right.
Joe.
Have a good day, everyone. Thanks, John.
Bye-bye.
See ya.